So just to open up, the topic today, of course, is IT disputes, and I'm supposed to intro this topic by talking a little about IT contracts and IT disputes and why we think this is an important subject matter. So for through the years, in our practice, we've advised at various stages of IT contracts, and typically it starts the role of the lawyer usually is at the beginning, and then never more. So normally, in the course of an IT project, if you're an IT manager, or if you're on the client side, or if you're on the supplier side, the first thing, one of the hurdles you need to get through once you have an agreement in principle is to have the lawyers review the contracts. And so this is a normal thing for the lawyers to come in and look at the contracts and sometimes have a meeting or two, negotiate certain things out, negotiate some certain contracts, certain contractual clauses in, and therefore move forward on that basis. And normally what happens, I guess in 99% of the time, the lawyers never see the contracts again, never hears about the issues that arose during the contract implementation. And normally, if you do hear from them again, that means that there's a problem. And the problem could be initially a potential dispute. And in some cases, it goes into a full-blown dispute where you do need to prepare for resolving the dispute either through the courts or through arbitration. Now, why did we focus on arbitration for this event? And the reason for that is because, number one, it's becoming a more common mode of resolving IT contracts. But the other thing that we're seeing is that under the government procurement policy law, there is a requirement for government contracts that there be an arbitration clause. So, in fact, there have been arbitrations on government contracts that have had problems. And as we saw about 2 or 3 weeks ago, and we had Arup Meiti talking about managing IT projects, the chances for failure are actually quite high when it comes to IT projects, especially in these complex IT projects where you're trying to marry hardware and software. They have to work together, and there are various service providers. I remember about 10, 15 years ago, there was a big project that we were trying to find some resolution, and there were problems. Various government agencies had decided to collaborate to build a common database. And what happened was they each brought their own budget into it. And in the course, they pushed through with it, but some of a lot of the hardware had been bought, so the PCs were bought, but the software was still in development, and then the other components couldn't be implemented. And so that project inevitably failed. No dispute arose from that. But today, we're seeing a lot of large-scale IT projects coming out there. PhilSys, or the National ID System, is one of them. EODB, Ease of Doing Business, are also, or through ARTA, are also having these large-scale IT projects. And we're going to see more and more of these. And so we're anticipating that there might be some disputes, and hopefully today's episode will help you navigate through them. Now, in my experience, what helps is, and any lawyer will tell you if you're in a dispute, what helps is having the evidence on the ready. And if you look at the contract, the way that it's written, and if you practice good project management principles, then you should be documenting every phase of your development, right? You should have weekly meetings, you keep your minutes, make sure that everything is documented, because it is this document, right, this record of the meetings and the progress of the project that will become the basis of the evidence that you will present in case it does come to a dispute resolution panel. But even before that, one of the most helpful things you can do is to, in the contract itself, or if it's not a contract, if it's a scope of work, you make it very, very clear what the deliverables are in a project. You say, okay, you have to deliver software that has these functionalities, and you itemize the functionalities. And if you can specify what the functionalities are, that it is supposed to do A, B, C, and D, right? And you specify what those are. So when you do that, then it's very easy later to determine, was the deliverable sufficient? because then either side can show whether A, B, and C are present, or maybe A is present but B and C are not present. And therefore, it's very easy to tell whether or not the deliverable had actually been completed. The other thing that you can do to make it very clear is the timelines that you're going to set. So the contract should have very strict timelines, and you should specify when the deadlines are. And then ideally in these situations, when you set a deadline, normally there is a period for what they call acceptance. And that is when the customer receives the IT product or the service, and then they are able to check whether or not there are bugs, right, or unintended features. And then there's a correction period. So you can tell whether or not there's a delay. So these two things in the contract level are very simple rules that you can follow when drafting the contract to avoid problems later. But as I mentioned, it's also important to document the progress because in many of these types of disputes, it becomes a he said, she said type of problem. And you don't want a situation where the panel that will take the case will have to figure out who's telling the truth. But if you have very specific deliverables, very specific timelines, then it becomes simpler for the lawyer to prove who is at fault. Okay.